Ready, start. Called for record from the Assistant Commissioner of Income Tax, Circle 2, which also includes the investigation report on completion of extensive hearing, which included the papers of investigation in relation to the issue of client code modification CCM. Mr. B.S. Sorparkar, learned advocate on instruction, has made request to withdraw the petition. Mr. Bhatt, learned senior standing counsel, has objected to the said withdrawal as according to him, after a marathon exercise of pleadings and detailed submission on both the sides, with so much of investment of the time of the court, when the court is not inclined to interfere with the proceedings of reopening under Section 148 of the IT Act, decision of client code modification is required on merits opening on the validity of the reopening of the assessment, relying on the decision of the apex court rendered in case of Sariya Transport Service versus State Transport Appellate Tribunal MP Gwalior and others, reported in 1987 1 SCC page 5. Mr. Sorpakar, learned advocate, has urged that he be permitted this withdrawal, as he is not seeking the permission to once again approach this court under Article 226 of the Constitution of India. He added further that it would amount to bargain his challenge of reopening under the IT Act in connection with the notice under challenge. Mr. Bhatt, learned senior standing counsel, has relied on para 9 of the state decision to urge that whether to permit with reasons or without the reasons is the discretion of the court, which needs to be exercised even if it permits with withdrawal without any request for once again approaching this court. Appeals are pending, and the applications for staying the operation of the assessing officer also have been filed long ago. A cohesive mechanism is initiated and the appeals are not proceeded with. Today, the matter was taken up for hearing. Learned Assistant Government Pleader Mr. Soham Joshi has produced two communications addressed to him by respondent number 2. The same have been taken on record. A communication dated 14th September 2021 addressed to learned AGP Mr. Soham Joshi, where he has ensured to complete the adjudication of pending appeals within 8 weeks, to which the petitioner is satisfied, and the two aspects have been pressed into service. Firstly, about the pendency of the application of stay moved before the concerned appellate authority and the issue of pre-deposit under Section 73(4) of GVAT Act in two of the appeals. As the petitioner is already before the tribunal, which has ensured to adjudicate expeditiously and complete the entire process in 8 weeks period, making out of the extraordinary circumstances for the tribunal not to insist on the pre-deposit, can be argued before the appellate authority concerned, so far as the issue of coercive recovery is